Please be seated and turn off cell phones off.
Thank you, Mr. Lester. All right. Good morning, everyone. We're here for Defendant's Motion 26 for a change of venue, and I see that there's been an addendum. Defense ready to go forward? Oh.
State's ready.
It's the defendant's motion. Defense ready to go forward with the motion? Okay. And state's ready. All right. When everyone's settled, I'm ready for argument.
Your Honor, with regard to the defendant's motion, we do have to present to the court and place into evidence our most recent offering to the evidence regarding the pretrial publicity in this matter, and we'll provide a copy to the state, to the court. We have two different groupings here, one of which is the last time that we have provided the court an update as to the press publicity in this case from local media. We have, since that time, we have a grouping which will ask to be, for purposes of this hearing, Defense Exhibit Number 1, articles from the Marietta Daily Journal as well as the Atlanta Journal-Constitution, which begin from February 23rd going up until just prior to jury selection beginning in the case. Secondarily, Your Honor, we would have Defense Exhibit 2, which includes the publicity which has been occurring, our best sampling to provide to the court regarding, again, the local media and newsprint from April 12th up until we finished last week. I provide a copy to the state. We would ask that obviously that'd be part of the record, as well as all the prior pretrial publicity matters of evidence that we have provided to the court in our previous motions for closure, as well as the motion to withhold handling of motions in limine until after jury selection, so that they would all be incorporated as evidence in this motion.
Problem with that?
No, sir.
Obviously, we would also ask the court to take notice and include as evidence, such as the court has already received, the jury questionnaires which have been provided in this matter and the voir dire which has been occurring since April the 12th of this year.
All right.
That's our matters of evidence. I don't know if the state anticipates putting any evidence other than argument.
We'll just be relying on the voir dire and what's happening here in court, Judge.
If it may please the court, we're here for the purposes of our defense motion number 26, which is a motion for change of venue. We have filed this morning an addendum to that motion. It's a very short addendum. Basically, in the process of reviewing this over the weekend, I recognized there was a juror that I had left off the prior filed motion, that being juror number 25. Also, inasmuch as we had questioned a couple of jurors on Friday and did not have that included, the juror 89 is also included as part of this motion. Your Honor, we're moving for a change of venue due to the inability to assure a fair trial for the defendant, Mr. Justin Ross Harris. That is, a change of venue being requested due to that pretrial publicity, which we believe has just pervaded this environment, this community in such a way that the court simply cannot be assured that we can obtain a jury that is fair and impartial toward or against, most notably, the partiality against Mr. Harris. There's a pervasive, persistent opinion of guilt that has been formed since June of 2014 that continues up to this point in time. We've seen it repeatedly over and over from juror after juror as they've been questioned regarding formations of opinions, maintaining of opinions, even strengthening of opinions, and unfortunately, as the publicity indicates to us, the emotionalism of those opinions. In bringing this motion, Your Honor, we're relying upon all statutory, state constitutional, and U.S. constitutional rights and protections that are be given to any person that's charged in a crime in this case. We've enumerated those in our motion, and any others that would pertain to that, we would rely upon those as well. In my presentation, Your Honor, I'm going to address the legal standards and principles that the court is to use in looking at this matter. We're going to talk about the actual environment, including the jury information from voir dire that we've had, obviously. We're talking about the timing of this motion, so it's very clear why it's being brought at this time, and then we'll end with talking about the remedy that's being sought in regards to our motion. It's important, I think, for the court to know, and I know Your Honor is aware this is not the first time Your Honor's been faced with such a motion. However, I think the nature of this case is very unique. Not only does it involve the death of a child, not only does it involve a murder charge that's somewhat unique in how it's been brought by the state, but it brings with it a lot of publicity, which has brought a lot of emotion, which has created a lot of opinions that, frankly, I believe set this case apart from many other cases, probably any other case the court may have handled in the past. Certainly it is in my limited experience. With the determination of whether there is sufficiently present such pretrial publicity to jeopardize the protection is basically left to Your Honor's discretion to make that decision. There's no magic mathematical formula that the court's going to be able to follow. There's no magic single answer to a question that the court could be looking for. And there's no magic prior legal opinion from the appellate courts that's going to just say absolutely yay or nay is how the court must find in this motion. Instead, it's going to require Your Honor to decide this question from your own sense of wisdom, justice, and moderation, as is displayed on the plaque that's sitting behind you in Your Honor position in this courtroom, to determine, can this court be satisfied and assured that Ross Harris can actually get a fair and impartial trial in this community, given the environment in which we sit. Of course, unfortunately, Your Honor also has to be aware that your decision is going to be scrutinized only by an abuse of discretion standard. However, you have the difficult position of satisfying not only your personal sense of fairness, but knowing and trying to foresee what others in appellate courts would be able to look for to see if they are satisfied in reviewing this matter, looking back on the record, looking back on the historical perspective that this case will have to determine if, in fact, a change of venue should be granted in this case. Let me start with the legal principles and standards. Some basic constitutional review is always good for us at a time like this, and I think it highlights the importance of this impartiality requirement. Sixth Amendment to the United States Constitution says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime is alleged to have been committed. Article 1, Section 1, Paragraph 1 and Paragraph 11 of the Georgia State Constitution similarly sets forth that no person shall be deprived of life, liberty, or property except by due process of law, and in criminal cases, the defendant shall have a public and speedy trial by an impartial jury. We bring our motion pursuant to 17-7-150A1, in which it says the defendant in any criminal case in which a trial by jury is provided may move in writing for a change of venue whenever, in the defendant's or defense counsel's judgment, an impartial jury cannot be obtained in the county where the crime is alleged to have been committed. So this word impartial is the constant that we see coming through each one of these protections and provisions. The question is, what is impartial? We've all struggled with answering that question as we've been asking jurors about that. I think ultimately we all agree that impartial means you have no preference of one over another. The statutory question not only requires that someone be impartial, but it says, are you perfectly impartial? Which I'd suggest to the court means there cannot be even any hint of a preference of one side or the other. Interestingly, when we look at these questions, the statutory questions, there's a specific framework set out by the statute as to how we should go about asking those questions and as to whether a juror can even be considered competent to be considered as a qualified juror. Ultimately, the court is able to look at the totality of the circumstances to show if there's substantial impairment to being fair and impartial, and notably from the statute, the juror's own conclusion as to whether they think they can be fair and impartial is to be considered, though it's not determinative, but it is a consideration that the court should take into account. Let's start with the statutory questions. In OCGA 15-12-164, the court has set out before it the framework by which it's supposed to ask questions of jurors to determine if they can be competent. And we're all very familiar with these questions. We've heard them many times. But I think it's important to note exactly how the statute says to go about asking them. Number one, have you for any reason formed and expressed any opinion in regard to the guilt or innocence of the accused? If the juror answers in the negative, then the question in paragraph 2 shall be propounded to him, which would suggest if a juror indicates that no, they have not expressed or formed any opinion, then we go to question 2. As we've seen over and over, many of our jurors, if not most, are not able to answer that in the negative. Question 2, have you any prejudice or bias resting on your mind, either for or against the accused? Again, only if they can answer no to that question are we then to go to the third question, which again, we've seen many who've been unable to do that. And then 3, is your mind perfectly impartial between the state and the accused? If the juror then answers this question in the affirmative with a yes answer, then they are judged and held to be a competent juror, which we could then look toward motions to strike. Part C of that code section says, if a juror answers any of the questions set out in subsection A so as to render him incompetent, or if he's found to be so by the judge, he shall be set aside for cause. I'd suggest to the court what that tells us, if they are unable to answer question 1 with no, question 2 with no, and question 3 with yes, then they are incompetent. They are unqualified. They should be, as the statute says, shall be set aside for cause. Obviously, the court also has the totality of a juror's answers en voir dire to determine if they're otherwise substantially impaired and their ability to be fair and impartial. And I don't believe that's mutually exclusive of C. It's if C fits and they become competent, then the court also has a secondary balancing opportunity to look at their other answers to see that although they pass the statutory questions, they may still not be competent, may not be able to be fair and impartial by their other answers. And again, it's in that part of the code section where the juror's own representation, whether they believe they should be fair and impartial, is to be considered by the court. So what is the measure this court should use to determine whether someone's partial or impartial? United States versus Wood, a 1936 U.S. Supreme Court opinion, gave us some help in that regard, though frankly I think it tells us what a difficult decision this can be. It says, impartiality is not a technical conception, it is a state of mind. For the ascertainment of this mental attitude of appropriate indifference, the Constitution lays down no particular test, and procedure is not chained to any ancient and artificial formula. Which again just leaves us with, ultimately, it's the discretion of the court. That's why Your Honor has a very weighty responsibility in looking at this question. Next question is, well, how is that prejudice to be shown? Well, in order to find that a petitioner does not receive a fair trial on appeal of review, the petitioner must show either inherent prejudice or actual prejudice. Just one example of that principle is Street versus State, 237, Georgia, 307. We offer both of those in this case, both inherent prejudice as well as actual prejudice. Starting first of all with inherent prejudice, looking at Morrill versus State, M-O-R-R-I-L-L, 216 Georgia Appeal 468. Again, just one of many cases that talks about this. It gives us a list of things to look at, to consider, and cites multiple other cases in that regard. The size of the community, the extent of the media coverage, whether that coverage is related to the discovery of the crime or to the apprehension or interrogation of the defendant, the prominence and content of the reports, that is facts versus speculation and emotionalism, and the accuracy of those reports, the time interval between the publicity and the trial, the widespread community fear and bias, a barrage of inflammatory publicity immediately prior to trial, amounting in a huge wave of public passion, or a total inundation of the judicial process by the media at the trial. We all know Cobb County is a metro Atlanta community. It's a very large community. But this case has been one of the most widely publicized, most reported on in both local television, local radio, national television, and internet reporting based upon what we provided to the court and the press clippings that we've had. The court's been able to see not only reports made by local media, but also the reaction by that. And I think that's especially important when the court looks at determining what are these people who would be called to sit in this jury box, what are they exposed to? What have they been exposed to? Not only the media itself, but what's the resulting community bias, prejudice, or partiality involved in the case. First of all, we know it's been voluminous. I don't think there's anyone that will question that it's been a voluminous amount of pretrial publicity in this matter. Since June 14th of 2014 until the present time, it has been before these citizens. As one of the jurors said, I think rightly, if you live in Cobb County, you've heard about this case. Now, to what extent that is, whether it's a passing moment or it's a reading of every single article that we've heard George mention has happened. Either way, it's been very voluminous and it's been quite emotional. It has reported on alleged statements by the defendant, gleaned from court proceedings in this matter, search warrants, proceedings that were brought about by law enforcement, and how they've orchestrated testimony in this case, how they produced information to magistrate judges, how they released that information to the local media. Obviously, a lot of these reports have focused on the victim, Cooper Harris. And although there's nothing wrong with doing that, the nature of this being a 22-month-old child and the nature of his death, as horrible as it was, causes that reporting to, if not have a certain slant, certainly create a certain emotion in those who are hearing it. There's been much reporting over sexting allegations, including a new indictment brought by the district attorney about a month ago, right before we began picking jurors in this case. It's resulted in very emotional, very personal commentary against the defendant. We've seen it on national television. We've seen it in local media. We see letters to the editor, comments to the editor, such horrible, horrific comments referencing the very thing the state has questioned each juror about: what's potential punishment? Foregoing any issue of guilt or innocence, people discussing about how they think Mr. Harris should be punished for this. Horrific things from bringing back old Sparky, referring to the electric chair, to allowing him to be literally tortured to death. And while those emotions may be understandable, the question for the court here is not whether or not people should have those emotions. The question for the court is there evidence that in fact they do? And that has pervaded this community in such a way as to prevent a fair and impartial jury. Unfortunately, there's been quite a bit of incorrect reporting in this case. And that's a note, and we'll note that as heard from potential jurors. Let it be very clear. The reporting that's been happening consistently, even in those items we produced today, even a year and a half later, still contain incorrect reporting claiming that Mr. Harris searched and researched for child deaths in cars. That is not true. It has never been true. The law enforcement has set out and made some statements to suggest that. They have testified under oath to magistrate courts that not only did that happen, but he stated that he did that. But the court's aware, because we've heard it in this very courtroom, he did not state it, he did not do it. And that single piece of incorrect reporting has so greatly affected people, and we've heard it from jurors in this questionnaire as they come and testified, that my goodness, if he's researched how to kill a child in a car, how long it takes for a child to die, that one piece of incorrect reporting, I would suggest, is greatly responsible for a huge amount of improper emotionalism and inability to receive a fair and impartial jury in this case. This publicity has been constant. It hasn't let up. The slightest thing that occurs in this case, scheduling orders, meetings, even courtroom times that we don't even have court get reported on. We've seen that happening. It has resulted in a community bias against the defendant, and there's been a total inundation of the judicial process by the media. In fact, I'll just note for the record, we now have adorning our courtroom 2 media cameras provided by one of our production companies that are here. One over the exit sign that the jurors will walk through every single day as they walk back and forth to the jury room. One behind me, so you stand here where we present our evidence and ask questions. Just outside this courtroom is a makeshift production studio. Don't know if the court's even aware of it, but I want the record to be very clear. In the conference room outside this courtroom is I'm not even technologically savvy to know exactly what it is, but it's grand. 2 large screen televisions with all sorts of production capabilities, including, as you walk out of the courtroom, down the hallway, new electronic wiring through this courthouse to allow production of this, telecommunication of this, even what appears to be a microwave satellite dish that's sitting in the hallway of this courthouse as you come to this courtroom. Of course, a simple look outside, and the press clippings show this too. There's what's referred to somewhat as a tent city of reporters that are here every day making live reports from various places around the courthouse that, again, jurors would have to pass by each and every morning as they come to court. Now, again, I'm not suggesting that the press should not be doing that. They certainly have the right to record and to report upon these things. But the issue is, what are common, ordinary people who see this media onslaught at the courthouse going to be subjected to? What expectations might be on their minds that, wow, this is something big and everybody's watching us, and we know everybody hates him. We know they've got opinions. Heck, half of the jurors we've talked to, some of those who've even been qualified, already have those opinions of his guilt. We submit to the court there has been inherent prejudice to a fair and impartial trial in this case. But secondary to that, there's actual prejudice. And to answer that question, whether that's true or not, we have to look at the actual individual voir dire from these jurors to determine what does that tell us about their ability to be fair and impartial. Well, the appellate courts have dealt with this issue many times in the past, and we've seen several change of venue motions which have been denied that have been upheld for much smaller percentages, 7%, 9%, 13%, 15%, 17%, all of which have been determined not to be sufficient. Interestingly, in the Edenfield case, Edenfield, it's 293 Georgia 370, we see there a large percentage of a third, 33%, or slightly more than a third, as the opinion tells us, of the prospective jurors in that case indicated that they had heard something about it before trial. But most of what they heard was limited in scope, not what we have in this case. It was not inaccurate, which is not what we have in this case. It did not concern matters that would be inadmissible at trial. That somewhat still remains to be seen, although frankly most of what the state has asked to be admitted has been ruled upon to be admissible. and it revealed little that would not be made known at trial. Well, there's a lot that's going to be made known at this trial that's not been revealed previously in the press. In that case, the Edenfield case, extensive individual examination was allowed to be had. It was determined at that point that those jurors, the prospective jurors who were found qualified, did not have any fixed views. They could be fair and impartial. They said that they would be able to set aside anything that they had heard before trial and consider only the evidence presented at trial. That's simply not where we find ourselves. Thank you. As to another case, Chancey versus State, 256 Georgia, 415. In that case, we're dealing with the court finding that even around 40% of such bias and prejudice being okay in certain circumstances. That was a case handled in Walton County, which obviously is a smaller community than ours, and the case addresses the local newspaper accounts and as well as the Atlanta paper accounts of that case. It notes this in that opinion: the record of publicity in the months preceding and at the time of the trial does not reveal a barrage of inflammatory publicity immediately prior to trial. Not what we have in this case. Amounting to a huge wave of public passion. That's exactly what we have in this case. It's a wave of public passion. In that case, they found there was no evidence of total inundation of the judicial process by the media. We were literally inundated by the media as we sit here today as the court looks out on this courtroom. And the court in Edenfield said, we cannot say that the setting of the trial was inherently prejudicial as a result of pretrial publicity. However, they also looked at the actual prejudice and determined all that is necessary to hold is that the fact that approximately 40% of the veneer was excused for cause due to prejudice against the appellants did not demand a finding that the jury selection process showed actual prejudice to a degree that rendered a trial fundamentally unfair. And I offer that to the court, frankly, to let the court know that, yeah, the appellate courts have given this court wide latitude in looking at even the numbers that we have in this case. And we're going to talk about those shortly. But I think the United States Supreme Court gives us a better barometer to look at how this court should view this case. In Irvin v. Dowd, 366 U.S. 717, we saw that 2/3 of the jurors had an opinion that the petitioner was guilty, and they were familiar with the material facts and circumstances, included that the murder was attributed to him, some going as far to say that it would take evidence to overcome their belief. Well, that sounds very familiar because that's what we've been hearing in this courtroom. One said that he could not give the defendant the benefit of the doubt that he is innocent. Again, what we've heard repeatedly in this courtroom. Another stated that he had a somewhat certain fixed opinion as to petitioner's guilt. What we've heard and worse in this courtroom. But here's the important thing. Here's what the Supreme Court tells us. No doubt each juror was sincere when he said that he would be fair and impartial to petitioner, but psychological impact requiring such a declaration before one's fellows is often its father. In other words, as these people sit here and they want to be fair, they want to say that they won't prejudge Mr. Harris, they want to satisfy the prosecutor who's asking them very direct, leading questions that, sure, I'm not going to tell you right here in front of the judge I won't listen to the evidence. I'm not going to tell you right here in front of the judge that I won't listen to the law. Absolutely, I want to be able to do that. But even many of those who have even indicated yes to that question have said, but I don't know that I can do that. I'm not sure. I'm going to do my best. And the state seems satisfied that, well, just do your best. Your Honor, we're not satisfied that people are going, even in trying to do their best, that they can be fair and impartial. That they can somehow break the bonds of the emotionalism that this case has carried due to the pretrial publicity and render a true, fair, and impartial verdict. And that's ultimately what the court has to determine. Can you be satisfied that these all these factors are so clear to everyone here, even these jurors sitting here who are telling us, many of them, gosh, I just don't think it'd be fair for me to sit as a juror. And they're right. They're absolutely right. Despite their beliefs and their desire to do the best they can, frankly, we just ask the court not to put stock in a hope that without seeing what's coming, without knowing what's involved, that as much as we appreciate their desire to do their best, let's ensure that we don't put them in a horrible burden, in a difficult position of setting aside all that is weighing against them as jurors in this case. I note Tyree versus the state, 262 Georgia, 395, where the conviction was reversed due to pretrial publicity because it gave factual information as well as provoking hostility or reflective of an atmosphere of hostility, which is shown by letters to the editor following reports, including comments made by the district attorney. I think what, again, the publicity in this case shows us, there's clearly an atmosphere of hostility. Not necessarily coming from the press itself, but as a result of the reports that have been made, and as a result of incorrect reporting that's been had, and as a result of ways in which information has been provided to this court and to the public through law enforcement, we believe has contributed to that. Jones v. State, 261 Georgia, 665, is an interesting case because it established a new rule, specifically in death penalty cases, that a change of venue should be ordered where there's been a substantial showing of likelihood of prejudice, a substantial showing of likelihood of prejudice by reason of pretrial publicity. Now, we recognize this is not a death penalty case, but this is the death of a child, and I think this court has very wisely been handling this case very carefully, and has been treating it in many ways like a death penalty case because we know that the emotional charge of this issue can affect people in wide and various ways, especially in a group context. So we'd ask the court to look at that for guidance in determining this decision. Now, in our motion, we've set forth a listing of the jurors' information that they provided to us. I'm certainly not going to read through that entire motion, but I do want to highlight each of these jurors as we look through them at some of the most egregious issues that I think the court has to be not only aware of, but consider greatly in determining its ruling in this matter.
We're on your exhibit.
Yes, ma'am. And I think what's interesting is to listen for those very things that have been provided to us by the Supreme Court as factors to look at in determining, do in fact we see this pervasive opinion through our community? Juror number 1 indicated that he had a bias until evidence was produced to change his bias, that the defendant would have to prove otherwise. He was going into trial leaning into the guilt side. We moved to strike for cause. That motion was denied. Juror number 3. That juror indicated that guilty.
Wait.
I'm sorry.
Y'all didn't put that in your motion, and I want to make note of that.
Thank you very much.
Okay, so juror number 1, defense motion to cause denied. Cause. I'm ready.
Thank you. Juror number 3, again, this is a motion to strike for cause which was denied.
Okay.
This juror indicated that guilty was her starting point. Now, and I think in looking at it, the court certainly heard the juror say that she would do her best to honor her jury oath. But she also added it would be very difficult to change my mind. She could not say 100% that she could follow the oath. But guilty was her starting point, and she had an inability to be impartial. So even though she answered a question of the state that sounded good in and of itself, in the totality of that juror's explanations, which the court has given authority to look at, we submit to the court it's very clear that she simply can't set that aside. She's not setting that aside as she would begin her jury service. She hopes to, she wants to, she would do her best to. And we don't have any doubt as to the sincerity of that response. Unfortunately, what history tells us is that's not sufficiently reliable in order to allow this person to sit on the jury. Juror number 4, it was agreed upon by the parties, and the court agreed as well. This juror was struck for cause. Why? She said it was hard to set aside her opinion, hard to follow the law. Now, she was a complete strikeout, if you will, on the statutory questions. And just for purposes of the record, to make it clear, it's probably clear to Your Honor, but in our motion, we've set forth under each juror's number, 1, 2, 3. That's the juror's statutory question answers. And certainly this is not a verbatim record. This is the best drawing upon our notes as we were taking through this. Obviously, we defer to the official record as to any responses that were made. But when I refer to a strikeout, I'm meaning on each of the 3 statutory questions, they've answered number 1 and number 2 in the affirmative as opposed to the negative, and then number 3 in the negative as opposed to the affirmative. I'll note juror number 1 was not able to answer question number 1 in the negative completely. Juror number 3, number 1 and number 2 questions also was not able to answer in the negative. Juror number 5, again, a complete strikeout on the statutory questions. Referred to this case stating that a serious line had been crossed in the jury questionnaire, had expressed bias and prejudice, and unable to be perfectly impartial. Indicated he did not think he would be a good juror, excuse me, on this case. That motion to strike for cause was denied. Juror number 6, this motion was granted. And notably, this juror indicated on the state's questioning that he thought he could and would do his best to listen to the evidence and follow the law and render a verdict based upon those 2 things. However, he then offered his opinion that the defendant was guilty. Not only that he was guilty, but this crime was premeditated. Ultimately, even the state understood, or at least, excuse me, the court understood that clearly that was not a qualifiable, competent juror. Juror number 11, again, this was agreed upon by the parties that this juror should be struck. They indicated that it would be very difficult to be fair and impartial because this involved a little child. Again, this juror indicated they did not think that she would be a good juror for this case. Juror number 12, a complete strikeout on the statutory questions. Again, this juror, it was agreed upon by the parties. This juror should be struck. And among other things, having an opinion that the defendant was guilty, this juror was biased and in favor of the state, that as a parent, she stated that the defense of accident simply was not plausible. And that's an underlying issue that we're dealing with here. Because this involves a parent charge in the death of their child, small child, that any parent that comes in here and sits as a juror has that potential partiality in their mind. It's just natural. Again, nothing wrong with that, but to assume that they can set that aside, some can, I don't doubt, but for most, humanly, it's too much to ask for someone who set that aside, given the environment we're in here, and render a true and just verdict in the case.
I want you to go back to 6.
Yes, ma'am.
And whose motion, or was it a consent or what? Because I didn't get that as you were saying it, and I was looking at some other things about the numbers.
Right. Your Honor, I believe number 6 was a defense motion. The state argued, opposed it, and Your Honor granted the motion excused.
That was my recollection as well, Your Honor. I misplaced my jury sheet that would have that answer, but I agree with the state.
I had just struck him, and I didn't have it written down as to those aspects of it. It's in other notes. I just didn't want to have to track it down. Okay.
Thank you, Your Honor. As to juror number 14.
Oh, and juror 11, was that a consent for cause?
Yes, ma'am.
Then wait.
Juror 11 and 12 both.
I've got that. Good. Okay, now, Sorry I interrupted, but I wanted those notes.
Thank you very much.
And I was sorry, I was doing some math at the same time.
That's okay. That's better to get it on the front end. I agree.
No kidding. Okay, let's go to 14.
14, that also likewise was an agreed-upon strike for cause. And indicating having heard news about this case on national media, the juror said he did not think it was possible for a person to forget their child all day. And it looks as though I have a typo there in our motion.
I saw that. Sorry.
But to forget their own child all day, and the defendant is guilty as to that aspect. This opinion cannot be changed. And again, they could not presume the defendant innocent. For that reason, I believe the state agreed. This juror number 18, complete strikeout on the statutory questions. This juror was agreed upon, our motion to strike, was agreed upon by the parties in the court. Again, why? The juror said they could not presume the defendant innocent. Could not say that she would put aside all that she had heard about the case. Again, this is based upon past media coverage as well as talking with family about that matter. Juror number 3, notably, this is a motion to strike for cause that the state opposed and the court denied.
You mean juror 23?
Yes, ma'am.
I'm sorry.
Juror number 23 had heard about the case and formed an opinion over a year and a half ago when they first heard about the case and the reports on the case. That opinion was the defendant was guilty. And notably, that juror would require the defendant to prove that he was not guilty. She was trying to be impartial, trying to do her best, but the defendant would have to prove her wrong. This is even after the state was questioning her in an attempt to rehabilitate her. She made that comment. Unfortunately, that motion was denied by the court. Juror number 24, total strikeout on the statutory questions. And for clear reasons, this was agreed upon, the motion to strike was agreed upon, because even under the brief the examination by the state, juror indicated that could not be fair and impartial, could not set aside that opinion. Juror number 26. This again was a motion to strike for cause that was denied by the court. That was after a complete strikeout on the statutory questions. And notably, after talking about all the National Public Radio and Atlanta Journal Constitution press covers they were aware of, having formed an opinion of guilt, when asked if taking an oath would set that opinion aside, juror replied that she did not think so. The defense would have to work really hard to change that opinion. No, I don't have noted here. I presume there was some answer to a question that sounded good initially to the state and as they opposed this motion, but ultimately in the totality of the circumstances, it's clear this juror should not be considered competent and qualified to serve. Juror number 29. This was a motion to strike for cause which was granted by the court. Per my notes, I believe that indicates the state opposed that, but the court granted it nonetheless. Presumably, in part because they stated in the questionnaire, I've already judged him. When asked if there was anything that we could show the juror that would make her give up her opinion before hearing the evidence, she said no. And again, notably with this juror, she had incorrectly heard that the defendant knew the specific charges that might be brought against him while on the scene. I don't even know if that's been reported anywhere. There's certainly no truth to that. There's certainly no evidence of that that's been produced to this court. But in her mind, that's what she's heard, and that's what helps her get this opinion that cannot be set aside. Juror number 30, another juror which indicates, I think he's guilty. I don't think there's any reason for any parent to forget about a child. I believe he's guilty 3 times in the questionnaire before we even got to question the juror on voir dire. And again, When questioned very quickly, it was even clear upon the state's examination that was a fixed and definite opinion. For that reason, that motion to strike for cause was agreed upon by the parties in the court. Interestingly, the statutory questions, not a complete strikeout, although the first two questions certainly were. On that last all-important question, are you perfectly impartial? Juror answered yes, even though it's very clear from her questionnaire before we even questioned, I say her, him or her, that I think he's guilty. This partiality question is so vital, and again, because they're sitting here and they want to appear impartial, especially after they were informed by the court, you should have an open mind. You should have an opinion in this case. And they want to do what's right. But the reality is, because of what they're dealing with and their pervasiveness of this pretrial publicity, they simply cannot do that. Juror number 31, this is the motion to strike for cause. It's indicated to me that that was opposed by the state, but was granted by the court. Again, another juror who says, I know he's guilty. You can't forget being a child being in your car, and she could not be fair and impartial. This was an interesting juror, and it's somewhat of an anomaly, but it's notable that this is the juror who the court found that her demeanor concerning her answers, concerning what was going on in her answers about this were simply illogical. She clearly had an opinion stated in the questionnaire, and then she sat here and said, well, no, I don't have an opinion at all. I've set it aside. Now, she explained to us, well, part of that was because she felt like that's what she was supposed to do based on the instruction the court had given her. Again, the difficulties of our human nature is that we want to do what we believe is right, but the reality is we have opinions that are fixed and definite, and the court recognized that and granted our motion over the state's objection. Juror number 32, a complete strikeout as to the statutory questions. This one was agreed upon by the parties, that this juror should be struck. And notably, further incorrect information from pretrial publicity. This juror incorrectly believed the defendant had posted about a child-free life. There's absolutely no evidence that he ever posted about a child-free life. Also, incorrect claims that the defendant had researched hot car deaths and had posted or texted about being child-free, and that the defendant was not emotional around the arresting officer. That's simply not true. This court knows it. You've heard evidence. You've seen evidence. Absolutely, Mr. Harris was emotional, erratic, hysterical, as has been described by the officers in this case. Press suggests, and certainly law enforcement suggested, and wrote and stated under oath, well, he wasn't emotional. We noted he wasn't very emotional. The facts are that he absolutely was. And unfortunately, because of what law enforcement said, it got reported, and now that's helped create this pervasively biased opinion. Juror number 33. Motion to strike for cause was agreed upon by the parties in the court. Again, he had indicated initially that his opinion was not set in stone, but was not neutral. Ultimately, on our examination of the juror, found out his opinion was that the defendant was guilty. He would require the defendant to prove something, and he did not believe that he could take the juror oath. The state then attempted to rehabilitate the juror, and then he confirmed, if no evidence came from the defendant, then it would be tough to change my opinion. And that's one of those nuances that needs to be very careful. Even though one says, yeah, I can listen to the evidence, I can listen to the law, and I can do my best to apply those two. But if we're not asking that little nuance, which we did as this juror, well, even though you can listen to the evidence, listen to the law, are you going to have some burden upon the defendant in order to disprove something? And of course, they don't know what all the law is that the court's going to give them at this point in time. So fortunately, it became very clear, and even the state agreed, that that juror should not be qualified to serve. Juror number 34. An agreement between the parties and the court, a complete strikeout on the statutory questions. This juror noted he agreed that he did not feel it'd be fair for him to sit on the jury based upon his opinion gained from the press coverage in this case. Juror number 40. Now, I believe this is the last juror which there was a motion to strike for cause that was not agreed upon and that was denied by the court in this case. Interestingly, on the statutory questions, he indicated as to having formed and expressed an opinion. I'm not quite sure as to having formed an opinion, excuse me. As to having expressed an opinion, the answer, we've talked about it, but not about guilt or innocence. As to bias or prejudice, well, not personally. And are you perfectly impartial? No. Now, notably, when questioned by the state, this juror indicated that the opinion was not so strong, fixed, and rigid that she could not listen to the evidence and follow the law. What appears to be the standard. The talismanic question has been put to that juror, and she answered it correctly. However, the totality of the circumstances shows us, when asked whether she could set her opinion aside, she responded she did not know that she could. Her opinion was that the defendant was guilty, and she was not impartial. She did not presume him to be innocent. And it's that failure to accept the presumption of innocence that's at the heart, the very foundational bedrock of our judicial system. Juror number 41 was agreed upon by the parties. The statutory questions came right out. And question number 3, I'm partial. I feel like he's guilty. No, not perfectly impartial. He's obviously guilty, they stated in their questionnaire. The only remaining question was whether sentence to life without parole or be executed. Well, that was an easy one for even the state to appreciate. Okay, maybe that's a strong, fixed, definite opinion. And that person was struck. Juror number 43. Interestingly, as to question number 1, indicated they had not expressed an opinion, but as it turns out, she agreed that, as to the impartiality, the juror indicated that he's not perfectly impartial, even though they had first said that they were. Talking about it, having expressed an opinion, well, the opinion was that he was guilty, and the child due to the defendant's actions, and he was guilty because of it. Also, again, we see this incorrect information. There's been some reporting in their mind, they believe there's reporting that there was browsing history of looking for hot death. Was your opinion fixed and definite? Juror responded, well, it's pointing that way. He had expressed his opinion to his wife, even though he had told us originally in the statutory question he had not expressed his opinion, and ultimately agreed he was not perfectly impartial. Juror number 47, it's agreed upon by the parties. And the questionnaire indicated, I find the defendant guilty. It's too hard to believe he could forget.
Oh, go back to 43.
Ma'am?
Struck for cause, I have he was ineligible.
That is correct, Judge. We never even got to it because he wasn't eligible because he was a convicted felon.
Okay.
I will,
Regardless.
Thank you. I'll double check my number, see if I have that, an incorrect number on that, Judge. Because I have tried to account for all of those who were struck for cause for other reasons as well.
Okay, well, you might want to do that. I have him down as ineligible, but I also have notes reflecting a lot of this as well, so.
I'll double check my notes to see which number
Okay.
I'm referring to there, Judge. Thank you
Do
very much.
that, because what I've got down from the clerk is that 37 were struck for cause, 4 for medical reasons, 2 were ineligible, 1 had a hardship, 1 was a student.
Your Honor, I think Mr. Lumpkin's comments about when we heard him about what he said was correct generally.
Yeah, I
But
agree.
that he was struck because he was ineligible.
That's what my notes reflect, and that's what I would agree with, too. Y'all can just check on that, and then
Very good.
it doesn't mean I think it's unworthy of discussion. I just wanted to be clear.
Very good.
I wanted to be clear that I hadn't, that my notes were correct.
Absolutely. Thank you, Your Honor. And we want to be as absolutely correct in this matter. We did have the questions about this, but ultimately he was struck for a separate reason.
Right, but he was questioned.
Absolutely. Thank you. Juror number 47 indicated in his questionnaire that I find the defendant guilty. I stated that earlier. It's too hard to believe that he could forget. When asked if he could set aside his opinion, or excuse me, her opinion, she responded no, referencing the local and national news coverage of the case in 2014 when the opinion was formed, and that was agreed upon by the parties in the court. Juror number 48 indicated on the questionnaire they did not believe they could be fair and impartial, and referred to Cooper by first name in the questionnaire. That was question number 65 and 63. And although indicating to the state that she could set aside her opinions, on further examination it was indicated she could not presume Mr. Harris innocent and would absolutely require the defense attorneys to prove he's not guilty. So again, where someone has answered the question, yes, I believe I can be fair and impartial and set that aside, any opinion I have, when questioned further, not only can I not do that, but the defendant would have to prove something to me in order to overcome my presumption of his guilt. That motion for strike was opposed by the state, but was granted by the court. Juror number 50, again, a relatively simple one to agree upon by the parties, but notably, this juror indicated incorrect information received from the press, that the defendant had looked up articles on how long it takes for children and animals to die, and that the defendant had been on chat rooms and message boards of living without children. Simply not true. Now again, I don't know that that was actually reported by the press or how it was reported, but in its reporting about some of this incorrect information, this juror has now a bias, prejudice, and opinion that's incorporating this pervasive community bias against him. Juror number 51, again, was agreed upon by the parties. I note on question number 2, have a question mark there. As best I could hear the juror, their response to question number 2 was not at the moment, but again, I would defer to the record if it indicates a different word was used there. This is interesting. This juror had even indicated that she had an opinion, but she had determined to be more objective. This is a very interesting juror. This is a lady that had said she had listened to her husband, who is a much more objective person, and she had gotten to the point of saying, yeah, I've just got to put it all aside. I've got to listen to the evidence and make a decision. But at the tail end, when we asked that catch-all question, admitting that we don't always know the right thing to ask, she said, I want justice for that little boy. And that turned everything that she had said prior to that point to make it very clear to us exactly that even though she wants to set her opinion aside, even though she wants to say the right thing, the fact is that is still completely filling her mind, filling her heart. And the state ultimately agreed that she should be struck for cause. Juror number 52, when asked by the state if she were unable to listen to the evidence and apply the law, she twice told them she did not believe she was able to do so, and thus she was struck. Again, she was a teacher, and because of that status, she felt like, based on what she had heard from the Atlanta Journal-Constitution as her primary news source, that she did not feel like she could be impartial. Juror number 58, a complete strikeout on the statutory questions. Even said there's no doubt in his mind that he's guilty, that anyone who put the son in the back seat baking, even if unintentional, would be convicted. Well, that's a great example of the pervasiveness of this bias, this emotionalism. Even if I know that it's not intentional, I'm still going to convict someone, which is contrary to the law that the court would obviously give any juror that would serve. That was agreed upon by the parties and the court. Juror 59, again, a complete strikeout in the statutory questions. Asked if their opinion was so fixed and definite. They said yes, it was. So an easy one for everyone to agree upon. Juror number 64. Stated based on her I believe it's a female, her experience, her exposure to the media and her friends talking about the case, that we know enough to know what's being presented. Even as the state was trying to get at some of those questions, understanding you've not heard anything yet, she kept coming back, well, we already know. We've got it. We've got the press that's told us what's happened, so we don't need much else, if anything else. She could not consider anything as an explanation. One simply can't have accidents, and she could not presume the defendant innocent. Juror number 66, a complete strikeout on the statutory questions. This was agreed upon by the parties. Again, notably, in having the opinion that I think this guy did it, shown in the questionnaire, had some incorrect information that helped base this opinion, obtained from the media that somehow the defendant did not like his life and was not remorseful. It's indicated in question number 63. Again, that's simply not the evidence in the case. Also referring to the defendant as psychopathic, and there was no way anybody could make her feel it was a mistake that the defendant had to go down for this. Juror 66 said in the statutory questions that, yes, I'm perfectly impartial. But then when asked, ultimately, in his own opinion, he said it would be impossible for him to be fair and impartial. I don't know how we justify those two answers of one another, other than to say, again, the situation that's here, whether it be nervousness, whether it be emotion, whether it be tension, whether it be expectation, whatever it might be, that danger is so pervasive. Even when people are under oath telling us, I can be impartial. And then on the minutes later saying, no, I cannot be impartial. That's the sort of thing that should concern this court greatly, and in fact should concern the state greatly, that a fair and impartial jury cannot be obtained in this case at this time.
Judge, for the record, I think he said 66, that was 68.
If I did say 66, I did mean 68. Thank you, Mr. Boring. Juror number 69 indicated in the statutory questions that no, had not formed or expressed any opinion, had no bias or prejudice. And on the partiality question said that they were perfectly impartial, and then said no, they were not. Ultimately, what we find out when we look at their questionnaire and question them, on the three questions about fair and impartiality on the questionnaire, they indicated they did not believe they would be able to be so. Again, this juror referred to Cooper by his first name, question number 63. She told us she had formed an opinion quickly as a result of seeing news reports from the local TV news on WSB. She had incorrectly heard reports that the defendant had researched on the internet how long it takes for a child to die in a car. That simply is not true. She said she was not willing to accept or consider that this was an accident, and understandably so, based on incorrect reporting, incorrect understanding, and the bias and prejudice that she in fact has, the opinion that she in fact had, despite indicating initially to the court that they did not. Juror number 72, again, had incorrectly heard information from the media that the defendant had Googled, how long does a person have to be in a car before they die? It's simply not true. She did not believe she was able to be fair and impartial and could not say that she could set her opinion aside. Again, understandably, and we appreciate the candor which the juror had based on that incorrect information, based upon the incorrect pretrial publicity, could not be fair and impartial. That was agreed upon by the parties. Juror number 74, complete strikeout as to the statutory questions. Said she felt it would be impossible to complete a juror's responsibility. This is the juror who said, if you live in Cobb County, then you've heard about this case. We know there may be rare exceptions to that, but frankly, to be a Cobb County citizen is to know about this case, to hear about this case, and to be subject to the communal bias and emotion that goes along with it. Juror number 74, a strikeout on the statutory questions. It's agreed upon by the parties. Again, this is a juror who said she would follow the oath to the best of her ability. But it would be difficult and hard to separate what she'd heard in the past. Well, if the best of your ability is good enough, then this juror would be considered qualified. Ultimately, what we found out is that her prejudice was against the defendant and was in favor of the state, and that was her starting point as a juror, was to be against the defendant, not presuming him to be innocent. Juror 76. What did not appear to be a strikeout initially, saying in that last question, yes, I'm perfectly impartial. However, even when the state questioned this juror, he affirmed that he could take an oath to listen to the evidence and follow the law. However, he could not affirm that he would set aside his opinion. I think that's of note too, as the state is asking these questions. Though they initially were asking that question, they got away from that of, well, can you actually set aside your opinion? We know you can listen to the law. We know you can listen to the evidence. But can you actually set aside your opinion in order to do both of those things? This juror was not asked to do that. Ultimately, when we examined the juror affirmed that his opinion was pretty fixed. Juror number 77 stated, if it's done, it's willfully done. When the state asked at that point, could she set aside that opinion, she was not able to say yes. Again, this is a juror who had initially indicated in the statutory questions that she had a preference and said, ultimately, well, even though I've got this opinion of guilt, I believe I can be neutral in any preference toward the state. It just doesn't make sense. Clearly, that juror is not perfectly impartial. They're not neutral. They have an opinion against the defendant. That's their starting point. Juror number 80, strikeout on the statutory questions. Again, this juror said very clearly, I cannot presume the defendant to be innocent. Their opinion was ingrained in their mind that a child cannot be left in a car, and simply could not accept the principle of presumption of innocence. Agreed upon by the parties. 82, agreed upon by the parties. Statutory strikeout. Says 99% fixed in his mind so that he would be unable to apply the law apart from his opinion. Juror number 83. Indicated had no bias or prejudice, but ultimately had indicated to us about hearing incorrect reporting that the defendant had searched heat-related deaths and had an opinion of the report of the defendant wanting to get rid of his marriage. And incorrect pretrial publicity, which helping create that opinion based upon incorrect information. This juror notably said she understood the principle of innocent until proven guilty, but she still believed he was guilty. Even knowing what the principle means, accepting it for what it is, I still can't presume him to be innocent. And if he failed to testify, she would hold that against him too. Obviously, that was agreeable by all parties that was not a competent juror. Juror 88, this is one we took out of order, but interestingly, is very similar to the previous juror we just looked at. Had indicated there was reporting that the defendant wanted to get rid of his wife and that he had said that his child was excess baggage. I don't know that that report ever came out actually in the press, but in their mind, that's what they'd heard. That's what they believe was reported. And maybe they were reading some of these comments or some of these emotional reactions to the reporting that's been had. Again, the juror indicated they would have to hear evidence to set that opinion aside, and until then would be biased against the defendant. Agreed upon by the parties. Juror 101, we have not addressed on a motion yet because we've not gotten to that number before us yet, but we did question that juror out of order. And that juror made very clear, could not affirm that she would even follow the judge's instructions on the definition of negligence. Indicated when asked, could you be perfectly impartial? I don't think so. Juror number 239, again, one taken out of order. Interestingly, this juror, again, don't know where he got it from, but had some information in his mind that the defendant was researching how to kill and had dry ice in his car. That's so far-fetched, I'm not sure where that could even begin to come from, but we all clearly understand that that was incorrect. As to the addendum, the two other jurors that we've heard from, juror number 25,
Just a minute.
I see it's attached as an exhibit similarly
Oh,
on the...
I know. I'm just,
You have it?
let me get organized.
I'm sorry.
Just hold on.
Yes, ma'am.
I'm ready.
Thank you. As a juror number 25, again, had an opinion. She was not sure she could be fair and impartial due to involving the death of a child, question number 81. Ultimately, this juror was agreed upon by the parties to be struck for cause. Talked about, when she first heard about this case, it was particularly horrific, and that's when she formed an opinion of the defendant being guilty. And that opinion has not changed, which has been based upon the news coverage in the case. Lastly, juror number 89, the last juror we spoke to on Friday, had indicated very strong opinion against the defendant, that she indicated she was perfectly impartial. That's despite her indicating to us her opinion was the defendant was guilty, based on the news reports and what she'd been told by some law enforcement friends about this case. She could not affirm that she would set that opinion aside or that it was fixed and definite. Unique to her, she added she would be considering what evidence may have been excluded from the trial as she was considering a verdict. Again, one of those little nuances that you can't even begin to imagine that a juror, because of their friends in law enforcement and court reporters, I think she indicated, that she would have in her mind, well, I wonder what evidence they kept out, and maybe I'm going to use that against him, even though I don't know what it is. Someone who can do that, I think, again, just indicates the human frailty of being able to set aside the things that are in your background and in your mind that clearly, even though you want to take the oath, you want to do the right thing, simply is not able to do so. And, of course, even though she said she was perfectly impartial to the court's question, upon examination, she admitted she was not impartial due to the charges of inappropriate communications. So, as to the showing of actual prejudice, again, we know these jurors are trying to do their best, and they're hoping to be impartial, even those that we've not specifically addressed here. There's several others that we have concern that even if they say that they can be impartial, that when put to the test, they're not able to do so. They're human beings, Your Honor. We had to treat them as such, not as robots, not as automatons, but someone who actually has emotion, is affected by the community, is affected by the circumstances, is affected by the surrounding area. And our concern, frankly, is that there's an actual prejudice in this jury pool, and the court should look at that in ruling upon this motion. Very quickly, to finish up, I want to talk a little bit about the timing of this motion. This motion is not being brought this time to delay the proceedings in the case. We've tried to show pretrial publicity in prior motions for closure and to avoid motions being brought prior to jury service, but the court's found that to be insufficient at this point in time. So it seemed to be unhelpful to file this motion before the trial began, before the jury selection began, so we can kind of see exactly what the jurors are saying. We did not handle statutory questions in the typical manner. Most of these cases that we look at, we see the court gets the panel in first and asks the statutory questions, and then we kind of have an idea of what the whole pool looks like. Now, we're not suggesting it was wrong to do that. I'm just saying because we didn't have that in front of us, we couldn't know what the 239 jurors, where they stood from the very beginning. If that had happened, then that may have given us an earlier opportunity to know this. So basically what we did, we waited to have a sufficient sample to make judgments about this jury pool. Since we know from the case law that even up to 40% has been considered as not per se a violation, we figured, well, we probably need to at least look to see if there's 50% problematic. Maybe the courts will be bothered by that. So in looking for getting 42 jurors to strike from, we got to 84 jurors that we questioned, which would be double that amount. And that's the point in time in which we took what we had and we started putting our motion together so that we can present that on Friday. And that's where we were on Friday. Now, as to the numbers, I think it's helpful for the court to look at that. Again, it's not determinative in and of itself, but I think it highlights very much exactly what these numbers tell us. And if I could provide to the court, hopefully what will be helpful to the court in looking at these numbers. I never set myself out to be a mathematician, but I've tried to calculate some things that I think will be helpful to us. There's 2 sheets of paper I provided to the court there. Excuse me. And if I could, I'll just have one introduced as an exhibit for purposes of the hearing so the record will be clear of what we're referring to. The first one,
Brian, mark those as defense exhibits, maybe to the motion or something.
there's 2 columns there. They talk about jurors questioned. One page has 1 through 84. Next one has 1 through 89. The difference between these 2.
Okay, so you're going to do the 1 through 84 first and then the 1 through 89?
I think that probably makes better sense.
Okay, well, they need to be marked for the record in some way for people to follow, for us to follow too. Mark them, motion 26, exhibits. You want to make them exhibits A and B? So they won't get confused with the other
That'd
things?
be fine. Defense Exhibit 3, I think, is what would be for this motion.
All right, so A is going to be the jurors' question equaled 1 through 84, and B is going to be 1 through 89.
Very good.
I'm good. Go ahead.
Thank you. We look at jurors 1 through 84. And looking at those, I calculate that there were 8 jurors that were excused by the court. I have those numbers that are listed. We'll look at juror number 43, the court pointed out earlier, and see if I have misnumbered one somewhere, or maybe we need to add that one to it. But as you have it in front of you, from those 84 jurors, if we have excused 8, that leaves us with 76 jurors from that 1 through 84. Now, we know there were 3 jurors we took out of order. Those are jurors 88, 101, and 239. So if we included those in the question jurors, that would give us 79 jurors that are able to be looked at as far as motions to strike for cause. Second column, on motion to strike for cause, we see there were 40 motions to strike for cause the defense had as to those first 84 jurors. If you do the math there, dividing 40 divided by 76, which is the actual number that we had to look at, gives us a percentage of 52.63% of jurors we made motions to strike for cause. If we add the 3 additional ones, we also either have since made or will be making a motion to strike for cause, then that's 43 out of 79 jurors. That percentage goes up to 54.43%. Now, if we take out the 6 motions to strike for cause that have been denied by the court, then instead of having 40 strikes, that drops us down to 34. And again, if you add in the 3 that are out of order, that would be 37. That percentage at 34 is 44.74%, rounded up to 45%. And with 37, we get rounded up to 47%. So basically, the smallest percentage that we can even consider in this case is 45% of our jurors having motion to strike for cause that clearly they've either been agreed upon by the state or certainly with the court's approval of our motion that they are not qualified to sit as jurors. That exceeds even the Chancey case, which again, our case is much different than the Chancey case because we have all sorts of more extensive pretrial coverage, incorrect pretrial coverage, incorrect opinions based upon that, and quite a bit of an emotional response to that. And at a height of over 50%, some 54, nearly 55%. B, if we include through jurors 1 through 89, where we got through on Friday, basically we're able to pick up juror 88, and we have juror 84 and 87 that were excused by the court. So of those 89 jurors, if we take out the excusals, 9 excusals, that leaves us with 80. And if you were to include the other 2 that we did question but have not gotten to in the number yet, that would be 82. So those are the numbers we're working from. Out of those first 89, we would have 43 motions to strike for cause as we've gone through the list. 43 out of 80 gives us a percentage of nearly 54% struck for cause. If you add in the 2 that are out of order that we would certainly move for, that percentage goes up to 55%, or just shy of 55%. Again, if the court wishes to take out those 6, where the motion to strike for cause has been denied, we are still in the area of 46 and 47 to 48% of jurors which are not qualified to serve in this matter. Again, exceeding even the height of the Chancey case, which we've already mentioned is separate, should be looked at separately from this case. Now, what is it that we're asking the court to do? Well, it may be real obvious, but let's make it very clear for those who are listening. We want to obtain a jury that's fair and impartial. And let it be real clear, we don't want to have to move out of Cobb County to get a fair and impartial jury. We absolutely want one. We've wanted one from the very beginning. That's why, an additional reason why we didn't move for a change of venue earlier than Friday, because we were hoping, beyond hope, there might be a way to actually get a fair and impartial jury here in Cobb County. Our concerns have just been heightened and raised to the point that we simply don't feel like we can not address this issue and make it clear to everyone exactly what's happening here in front of us. But to the extent that we now believe that that's in protection of our client, that we need to not have a jury that's imposed upon it the communal bias and emotionalism that this case has, we're asking the court to move this case outside of the metro Atlanta media market in order to obtain a jury free from the press coverage that's had in this case. We know there's press coverage all over the place, and that certainly people that go into have heard about this case, probably no matter where we go in the state of Georgia. But to the extent that they're inundated by it, as this case has, and to the extent that they're overwhelmed by the community response. We heard juror after juror talk about going to work, going to school, going to church, going to different places where people just know about this, going to being around the location. Gosh, we know this is where that happened. Home Depot, one of our corporate heroes in our community, that involves so many people who are employed and work there and have some connections in this case. We're asking the court to go outside of this area to obtain a jury and then bring them back here to Cobb County to try the case. Obviously, there are some precautions that will go along with that will prevent any other pretrial issues from affecting those jurors if we bring them back here. But we believe if we do that, at least the court can be satisfied, the state can be satisfied, the defense can be satisfied, the community can be satisfied that, in fact, everything's been done to ensure a fair and impartial jury for Ross Harris. Obviously, we'll have to determine what location best provides that opportunity in accordance with all the necessary proportions and similarities to Cobb County, and we'll address that in the event that becomes necessary. In the event the court is not convinced that a change of venue should be granted, or even if the court may not even be convinced, but just says, you know, I feel like my job as a protector of our community is to say, we're going to take every precaution necessary to make sure no one can claim that anything was done improperly in this case. But if the court does not grant a change of venue, we would ask the court to reconsider its prior decisions on these 6 jurors who have been qualified to serve. Based on where we are now, I think, frankly, in the review of this, it's clear we all have gotten, quote unquote, better at this process. We know better how to ask those questions. We know better what question to ask. We know better how to probe into certain areas to get the totality of the circumstance from the juror. We've asked the state to reconsider its earlier opposition to some of these. It's notable that after the first couple panels of these, we began agreeing together as a motion for strike. And I think that's simply an indication that all of us are understanding better exactly what this process is and how best to handle it. And so we'd ask them to reconsider that. And if they don't, then of course we're going to ask the court to reconsider its rulings as to those. Because if nothing else, that will help eliminate some of these jurors who had the same reasons, same statements that jurors who have been agreed upon to be struck, that we don't have any hint of partiality in those jurors. So ultimately, Your Honor, our request on behalf of Ross Harris is that you err on the side of caution and protection of the most basic freedom that we have in our United States judicial system. That's what separates us from others in the world, that every person brought to trial by the grand power of the government of the state of Georgia is presumed to be innocent, and jurors who cannot presume innocence should not be part of the process. He'll not be convicted upon rumor and supposition, upon news report or talk show host soundbite. Unfortunately, that's what this case has brought about. The court is to protect every defendant from any indication of harm that can come from any opinion, bias, prejudice, or partiality that might enter into a trial. And our request to the court is to exercise your discretion. Make very clear that exactly that's what's going on here. This is not a case like the Miller case, as the state has been referring to multiple times. Well, as long as they were able to do their best, that's enough. And if they had said they were able to set their opinions aside without recanting on that, that'd be enough. We look at the jurors in that case, and it's notable. We'd ask the court to look very clearly. Don't just simply let the state tell you the Miller case says it's all good. That's not what Miller tells us. Looking at those jurors, we see one juror understood the presumption of innocence. We don't have that in this case. Another one said they'd have no difficulty setting aside what they'd heard about the case. We've had much difficulty setting aside opinions here. Another juror said he could set aside his pretrial biases and base his verdict solely on the evidence. He understood the presumption of innocence. We don't have that. Another juror, she didn't know very much about the case, and she didn't always trust what she heard in the media. Because of that, she had formed no opinions, and she could set aside what little information she had heard. Well, we don't have jurors with little information. We have lots of information, overwhelming and incorrect information. Another juror said they did not have a fixed opinion about the guilt of the defendant in that case, and he supposed they could set aside any leanings or inclinations to decide the case solely on the evidence and the court's instruction. Well, we have jurors who aren't saying, I suppose I can, I hope I can, is what they're telling us. Similar other jurors are recounted in that opinion, and I think it's just helpful to look at those very specifically. Again, one juror who could not recall any specific media report stated she would do her best to be an impartial juror. Well, if you've not heard any media reports, we don't have the pretrial publicity issue. So to claim that this case stands for the proposition that as long as they said they do their best, that's good enough, simply is not what the Miller case holds. Your Honor, we'd ask the court to strongly consider our motion, strongly consider what you've experienced over the last few weeks. We have all worked very hard. No one wants to have to start this process over. However, I think more importantly, no one wants us to have any question at all in our minds that Ross Harris was provided a fair and impartial trial by jury in this case. Simply put, I don't see how the court can be satisfied that these jurors, given these opinions, these statements, these answers, this community, this environment, this bias, is simply too much to ask Cobb County jurors to hope they can set it aside, to put them in a position where they simply are overwhelmed by all that is around them. For that reason, we've asked the court to change the venue in this case, as we set out, allow us to go get a fair and impartial jury in another jurisdiction outside the persistent, pervasive opinion that exudes Cobb County. Thank you.
do we find a fair and impartial jury, a legally qualified jury for the defendant in Cobb County? Well, Judge, the 3 past weeks have answered that, and the defense has admitted as much. At this point, we have, not even counting the jurors that we fought over and argued about, there are 36 jurors, enough for 12 to sit and for 2 alternates that the defense has agreed are legally qualified. How do we do it? We've already done it. Judge, and the only reason we are in this position and that you are in this position now is because of defense strategy. They can talk about it all day long and excuse it, but a strategy knowing, starting with the prong of inherent prejudice, the very evidence and reasons that they gave here today have existed since at least as far back as we went into that media motion. A completely different legal argument, nothing in that motion that they argued, the evidence they presented, the arguments they presented, kept them from saying, well, we can't close the courtroom, but maybe we could change venue. This is the same motion they argued then, the same issues in the same media that they complained of, yet continue to exploit for their own cause. This is a strategy basically taken from a playground in the backyard of somebody's house. It reminds me of going to play wiffle ball with my brother as a youth. We would go out in the backyard. He would always want to play a bat first. I'd say, okay, as long as you go play, you can bat first. And I'd strike him out. Things wouldn't go as well as it was planned for him. You know what he would say after he had decided he wanted to start? You know what? That was practice. I want a do-over. That didn't count. Those runs don't count, those strikeouts don't count. I want to start all over again because it didn't go my way. Your Honor, this issue of venue has been on everyone's mind for months. It was brought up in conversation before trial. It's brought up in conversation during trial. We have no motion, we have no motion, we have no motion. We were all provided a number of questionnaires in this case with the same obvious concerns that the defense is saying they have now. No motion. And look at how it's broken down, just looking at some of the jurors about the first 12, the first 24, the first 36. The same issues present. Looking at the people who had an opinion of guilt at that point, 12, 24, 36. When we got to the point of 36 jurors, about half of them, 18, had formed some opinion of guilt whether they were struck or not. That's about 50%. Was there a motion then? No. When you look at the next 36, there was actually less people who had an opinion of guilt. So things got better from their argument's sake. But after that 36, did they know? Because they thought they had a great number of pro-defense jurors. And they wanted to gamble the county's resources, everyone's time, knowing that the same issues that were here for inherent prejudice back in a year ago, year and a half ago, they waited. And only when we got further in the jury selection and they see things balancing out, do they now come and ask you to change venue. So what has the process shown? We had all this stuff they could have argued beforehand. We had these questionnaires. What has jury selection shown us? It's shown us we can get a qualified jury. We have 41 qualified jurors only, and I will say this, Judge, just to let you know, juror number 3 that they argued, we emailed over the weekend, we talked about it, I looked back at that questionnaire, I looked at the transcript, we looked at her, she had some severe hardships as well, and you know what? We said, okay, we're not contesting that, juror number 3, fine. We're gonna concede now, strike that one for cause. If you consider that, even with that strike for cause, you have 36 qualified jurors. And Judge, we didn't even need half of the people who were actually called in to Cobb County Superior Court to get to that point. And this is by the defense own admission. We don't object, these people are qualified. It's absurd the defense would now argue we need a venue change. Not weeks ago when this was in question, but now that we've proven we can. Judge, looking a little bit, first of all, at the standards you're to look at, when you look at their motion, the first motion, it shows a little bit of their argument and how they're having to twist this to try to get this venue changed. They cite in their motion death cases, and they cite the standard of change of venue in a death penalty case, which is completely different than a non-death penalty case. And they try to analogize it by saying, you know what, he's looking at life in prison, this is analogous to death. The very cases that they cite go to great lengths to point out how different it is in a death case. They say the difference between death and life in prison is just as different as 100 years in prison versus 1. That is not the standard. So based on that motion they filed, I'd ask you to completely disregard any argument in there about that standard, because it's improper. The standard you're to look at, basically, if you look at the Powell case, which we've already cited earlier, ad nauseum, venue can be changed, and it is your discretion, Judge. Either if it is shown that the setting is inherently prejudicial, which would have been something that would have been apparent before we even started jury selection, or if there is actual prejudice, which the Powell case, which is a 2015 Georgia Supreme Court case, not these 1961 pre-internet cases defense is citing, 2015 case, which holds that actual prejudice is when it is impossible to get a fair and impartial jury. And again, by the defense own admission and acceptance of 36 of these jurors so far, we can. As far as the inherent prejudice, Judge, looking at the standards, you look at the size of the community. In this case, several of the cases, they talk about small town syndrome. You have a lot of cases that involve towns of like 30,000 residents, 27,000 residents, things like that. The size of the community, that's not here, Judge. This county has something over 700,000 residents. It'd be more akin to the Skilling case, United States Supreme Court case from 2010, where they talked about the Houston metro area and how something with a metro area that large makes a big difference when you're trying to get a fair and impartial jury. And you saw several of the jurors here that the defense did not object to, that got through, that had never even heard of this case. You had some that had heard of it and had very basic facts. The extent and nature of the coverage, looking at the media coverage in this case. A lot of what the cases talk about when it's inherently prejudicial is they look at the fact that was law enforcement responsible for it, was the DA's office responsible for it, things like that. The defense specifically cited Tyree versus the state. That was a case where they talked about, it was found that the venue is inherently prejudicial. In that case, they said the DA's office and the sheriff's office contributed to that, and that made a big difference. Well, contributing to that in that case, the DA actually stated in an interview that he intended to kill the defendant because this is the only case where he's asking for the death penalty, and further went on to say that, yeah, if I had a gun, I would shoot him. Things like that. That was a completely different case than we have here. In that case, you had a published article linking the defendant with a serial killer who had been recently paroled. Had an article implying the defendant would attempt to commit suicide to get an insanity defense. The sheriff publishing a comment in the article about the defendant faking a suicide attempt. That's what we're talking about. Here, Judge, what we have is that they're complaining about media reports from search warrants where we've already argued in motion over the semantics of these things ad nauseum, about searches, about what he viewed, what he didn't, in open court where evidence can come out. when they talk about this media that they're complaining of that they're getting, this is the same media that they have tried to utilize for their own ends. The reason, and probably one of the main reasons that we even have this media attention, was because of the defendant and his supporters right after this incident. Judge, the media furor over this case was pushed by the defendant and his supporters immediately after arrest. There were petitions to get him out of jail, petitions and websites created to get him money, GoFundMe pages to help support his defense. There were websites created to impeach the district attorney here for pursuing this case. A magistrate court hearing, a probable cause hearing, that without the state's involvement, it was moved up 2 weeks and rescheduled 2 weeks before it was supposed to be handled. Press conferences talking about a maze of theories of the state put on by the defense, other attorneys speaking on behalf of the defense. It's funny they mentioned the new indictment and how that hit the media, Judge. The media had the indictment number before I did. And the only people who had contacted the clerk's office during that time frame would have been the defense to get that indictment number. And lo and behold, soon after that, what happens? Emails come to our office from the media with the indictment number. And just in that vein, Judge, there have been numerous media reports not sympathetic to the state, not sympathetic to the police, sympathetic to the defendant. Just so it's clear, this, even with the defense, one of the articles they put in here, they put in today, talked about questioning the evidence of the state. I think the title was, Do They Add Up? Now, what have these jurors been exposed to? Obviously, the law holds that the jurors qualified in a case do not have to be ignorant of every fact. What is key is, what are the jurors who are qualified to sit as jurors? What do they know about the case? And none of these jurors who are qualified had some knowledge of a fact that the defense objected to the degree that they tried to strike the juror for cause. They talk about cameras are set up everywhere here in the courtroom. Judge, no matter where we go, the cameras are going to follow this case. That's an expectation that's going to happen no matter where we go. So to come in here and argue that this is inherently prejudicial at this point is disingenuous. Now, to get to the actual prejudice, I think the strongest finding of actual prejudice against it is the fact that we have so many qualified already. Looking at the case argued by the defense, Irvin versus Dowd, a 1961 case. First of all, as we noted, different standards when there's a death case, not a death case. This was a death case. In that case, there was a barrage of newspaper headlines, articles, cartoons, and pictures unleashed during the 6 or 7 months preceding the trial. There were newspapers publishing stories about the case delivered to 95% of the county. The media carried details about the defendant's background, including juvenile crimes, 20-year-old arson convictions, AWOL court-martialed. They accused the defendant of being a parole violator. They reported his confession, which is huge, reporting a defendant's confession to 6 murders, and there were only 4 alleged. They talked about offers of pleading guilty in exchange for a sentence. Voir dire lasted 4 weeks in that case. There was a panel in the end of that case of 430 jurors. 268 were excused for cause for fixed opinions, just to show you getting down to what they found to be inherently prejudicial and actual prejudice. Out of those jurors, 430, 370 had an opinion of guilt. That is 90%. 90%. And 8 of 12 of the jurors impaneled in that case thought the defendant was guilty before trial. That is not what we have here, and that is not what the numbers bear out. What do the numbers bear out here, Judge? I'm going to differ with the defense a little bit on the percentages and things like that. Your Honor, I believe that you should count the ones that were struck for other reasons or that were excused. I think, first of all, our starting point should be the 84 jurors that have been put upon the state and the defense to make motions for cause or make our arguments or not. Because if you try to start counting other people that we jumped ahead and talked to and things like that, who knows what the other jurors within that panel would have said or whether they'd have been qualified. So that would completely skew the number. I don't believe that is an adequate or legal or appropriate number to start with. So I think we have to go through the 84 we have addressed. If you go through the 84 that we have addressed, what we see is that counting number 3, our concession on number 3, there would be 33 jurors that would have been struck for cause because of media. And I'll go through and tell you a couple of my exceptions to what they argued as far as whether they were struck for cause due to media or not, because I think that accounts for a couple of jurors off from what the defense would under my same standard. But under the state standard, what we have found and what we have seen through this, it's 33 of the 84 were excused for cause due to media concerns. That is 39%. That is a lower threshold than Chancey, which I would, Your Honor, that was a 42% case. I would note that that case, they specifically said, even though we're finding this 42% is not actual prejudice, we're not going to put a number on this either. So they're not even limiting it to 42%. They said the key is, can you get jurors who can be fair and impartial? Is it impossible to find a jury that can be fair and impartial? Judge, if you look at the percentages of who have expressed opinions of guilt, looking at the 5, you include those other 5 who we argued about and you overruled overruled the state's opposition, that's 38. 38 jurors out of 84 who had an opinion of guilt. Your Honor, that is 45%. If you look at the Chancey case, in that case, 60% of the jury pool had an opinion that the defendant was guilty. Again, looking at the first 36, if this were something that should have been raised whenever they saw it, after the first 36, there was a 50% rate of people who thought the defendant was guilty or had an opinion, arguably. And it's actually decreased since then. Going through the jurors, Judge, that we talked about here, that Mr. Lumpkin talked about, I'm not going to rehash all of the other jurors that we've made arguments about striking for cause or not striking for cause. We've already had the rulings on those. I'm not rehashing those. We've actually read through the transcripts. Those transcripts are clear about why Your Honor did not strike them for cause when the defense sought to. I think we've already addressed Juror 43. Juror 43 was questioned, and that's why I think the people who were excused for hardships or excused for being ineligible and things of that nature, they have to be included because, as the defense said, they were questioned and put upon the defense. This one, 43, was ineligible. The defense wanted to argue that it should be struck for cause instead of ineligibility, and you denied that request. There was mention of comments about Juror 51, just to point out justice for Cooper. She also said she wanted justice for the defendant. when they talk about how many cases the defense, the jurors, they show their bias by saying using Cooper's first name, there were a number that did not use Cooper's name, but actually used the defendant's name. Juror 77. That juror actually said that the opinions were fixed and definite because it involved the death of a child. That's something no matter where you go, because of this, you're going to have issues finding a fair and impartial juror because it does involve the death of a child. Your Honor, the defense asks, how can we find a fair and impartial jury here for the case of this defendant? It's very simple. Based on their own admissions that these jurors were qualified, we've actually got enough for a jury and a couple of alternates. All we have left now are to qualify a few more jurors to get enough alternates to be able to get through this trial. So, Your Honor, I believe that in your discretion, given where we have gotten and what this process has actually shown, note that the defense did not argue or cite statements of any juror who talked about how they were qualified or talked about how they could be impartial or talked about not having knowledge. There were a whole other side of that you heard from, that we heard from, that was not argued because it does not support their cause. So, Judge, I would ask you to deny their motion and that we continue this afternoon with jury selection.
Very briefly, Your Honor, thank you very much for your patience as you've had throughout the past 3 weeks, frankly, and again today. This is not a game in the backyard. It's not a bunch of little boys in here playing wiffle ball. It's a sad, tragic, difficult case. And we can't undo the horrible tragedy that's occurred. But what we're trying to do is prevent another tragedy from occurring. That's the court's job, is determine, brought before a jury, Ross Harris should have every opportunity to have a fair and impartial jury. The state would have us have filed based on belief and opinion. We've asked the court to look at evidence. The state appears to agree there was inherent prejudice, and it's slightly going away over time. If there's inherent prejudice, it should be granted. They disagree on the actual prejudice. And again, the math isn't the answer. They would have us include those people who have been excluded. Some of those never even made it to this courtroom. The defense did not feel that it was fair to include those in the count. Some with medical hardships that never made it here. Some, one that was post-certified, yeah, we didn't question him. One could presume where his opinion would be, but we didn't feel like that would be fair to include that person. One lady who couldn't understand English, and even though she gave answers that were helpful to the defense, we didn't feel like that was proper evidence. So the state's math can be done with whatever the court decides to do with it. I just simply point out we're here because what has become apparent. There's constitutional provisions, there's statutory provisions, there's defendants entitled to have a jury in the county. That was our hope. This is not gamesmanship. This isn't helpful to us. We want to get this case done and moved. We don't want to be uprooted or we've got no support structure that may be available to the state wherever they go around the state of Georgia. What we've got to do, we've got to ask, we've got to be here because the most important thing is that the constitutional protection is afforded to Mr. Harris. Despite what anybody else thinks, despite what the community bias may be, the court has one master to follow. What's the Constitution require? We're asking the court to enforce that protection for Mr. Harris. Yes, it's at a cost. It's at a cost that none of us want to have to take on, but we're willing to because we've taken the oath to uphold and defend the Constitution of the state of Georgia and the United States. That's what we're asking the court to do. Thank you.
All right, everyone get their notes out about jurors. I want to be sure that we all have an understanding of each juror and what each position was on how they came on the panel. Was there a no motion to strike, a motion to strike, by whom, and consent, or I want their status clear on the record, because in order to clarify it, you'd have to go through almost 90 of these, or plus. It's time to get it in one place with one understanding. Okay, juror number 1, I have that there was a defendant's motion to strike, and I denied it. Is that correct?
Correct.
Juror 2, there was no motion to strike. Is that true?
Correct.
Now, 3 seems to have changed. Apparently, the state is conceding that juror for health.
Your Honor, honestly, I think, all things considered, if you look at the totality and how strong she was in the hardship, and given the answers on the questionnaire, I think it would be fair to qualify her as a cause.
All right. Is the defendant having any problem with that?
We originally requested that she be struck for cause, Judge, so no, we don't oppose that.
Might not, just because you originally didn't. I mean, today is evident proof that opinions change. Okay, so it's a cause, it's a consent cause. Is that fair to say?
Yes, Your Honor.
Okay. Juror 4, was that a consent cause? I think it was.
Yes, sir.
What says the defense?
It was.
Okay. Because those are the notes I didn't make as we were going through. I have a note, but it's not as explicit as one might like. Juror 5, I think there was a defendant's motion to strike, which the court denied. Is that true?
Correct.
Okay. Juror 6, there was a defendant motion to strike, which I granted. Is that true?
Correct.
Juror 7, there was no motion by either side, correct?
Correct.
Juror 8, I have a note. Did we strike her for hardship?
Your Honor, she was actually qualified initially, but then she was exempt. We went through and we had arguments for cause on that, and then she was later found to be exempt. She was for medical.
Okay.
I think her mother had sick, I think it was her mother.
Oh, with cancer that was recurrent?
I believe so.
Okay, and her daddy traveled?
Yes.
Okay, all right. Juror 9, I have that there was a motion to strike, but I did not make a note as to whose motion was it. The
That was the state's
state's?
motion, and it was denied.
And that was because of a conviction?
It was
Yeah,
because of candor to the court, nothing to do with media attention.
okay. All right. Juror 10, I have there was no motion by either party. Is that true?
Correct.
Eleven, I have there was a consent to strike for cause. Is that true?
Correct.
And the same for 12.
Yes, Your Honor.
And 13?
13, there were no motions.
There were no motions. Yes, that's right. Yep, that's right. 14, consent for cause. Is that true?
Yes, Judge.
15 no motions.
Correct.
Okay. I think what y'all want to do is have me go through it, and then y'all just shout out when I'm wrong. Or I don't know. 16 was consent for cause, consent cause, is that right?
She was because of the language issue, Judge.
Okay, cause. Like, that's why I didn't write down cause, okay. 17, no motions? 18, 18 consent cause?
Correct, Judge, and the state's argument on that is it was not because of media attention, that was because she started, you may remember this year, started crying, and we started talking about having family members who were victims of homicide, and she said she could not sit because of that.
Okay. I do remember that. Up north.
Yes, I think it was Chicago.
Her brother, I think.
Yes.
Our motion was to strike the cause because of that being part of it, that she had an opinion because of what her family had told her and was reflecting what they were hearing about the press. I think Your Honor calls that.
Okay. I may go back and look at my notes of that and decide what category I want to put that in. Because apparently y'all's contention would be that it was,
It was due to pretrial publicity, whether it came directly or directly to her, in
Right.
addition to, or coupled with her brother's situation.
and your position would be it was just the brother's position. I'll take a look at the notes. All right, 19, no motion?
No motion.
20, no motions? And 21, no motions. All right, I know we struck 22. Was that a consent, or was that, that wasn't contested?
That was a motion for the state to strike a cause for being untruthful, initially denied, but when we came back later, last week, we
The
revisited it and we put evidence.
the Chattahoochee Tech,
That's correct.
okay. Uh, 23, no motions?
There was a motion to strike by the defense, Your Honor, that was denied.
Okay.
That's correct.
Okay. Twenty-four, what was that status?
That was a motion to strike the cause by the defense, and it was agreed upon.
Okay. All right, I'm just marking that as a consent cause. And 25 was a consent cause?
Yes, Judge. Right.
26, I have that there was motion to strike for cause. Was that by the defendant?
Yes.
And I denied it.
That's correct.
And 27, I have the same notation, is that correct?
We had made a motion to strike the cause due to the medical issues, as the inmate was pregnant, due to
Mm-hmm.
during trial time. I was denied.
Okay.
Yeah, Judge, she's still in the pool.
Right, she's still in the pool. She hasn't brought anything to our attention that she wants a hardship.
Correct.
And, you know, pregnancy is a healthy thing to go through, so it's up to her. You all advised her. Okay, so that was not for preconceived and prejudice and things of that nature.
Correct.
28, I have there was no motion to strike. Is that true?
Correct.
Okay. 29, is this where we start getting into consents?
I think there's several
I think,
in a row.
okay,
It's like 6 in a row.
there are, but there were motions.
Yes,
29 was a defense motion to strike, is that true?
yes.
That's correct. We motion by the state, but granted by the court.
Didn't, okay, yeah. 30, I've got a motion to strike. Whose was it, defense? And was it opposed by the state?
30 we agreed.
Okay, so that's a consent.
Yes.
31, there was,
Motion by the defense, opposed by the state, granted by the court. That's correct.
yeah. 32, I've got a defense motion to strike, is that true?
Correct, yes, that was a consent.
It was consent. 33, was that a consent or contested?
That's consent.
34, consent or,
Consent.
35, I have no motions, is that true?
Correct.
And Brian, you're going to speak up if we're wrong, right? 36, I had no motions, is that true?
True.
I think this is where you all started, basically, well, we're close. 37, that was a medical excuse. Was there an exception to me doing that?
No, Judge, I think we talked about it a bit, and then eventually, after a day or two, the defense talked about it, and they agreed eventually.
Did,
She never came to court, she's the one that provided.
no, she gave us, well, she had lung cancer, she had a lung removed.
That's right.
She had other problems that are indelicate.
That's correct.
I think we had 2 letters from her doctor.
Yeah, so, and I never was clear what y'all, I think it was just do what you want was what I was told. So I didn't bring her in here.
Mr. Rodriguez reminds me that we put a questionnaire into evidence that there was some stuff on there that hadn't had a chance to question her. We anticipated she would leave in a phone line. But ultimately, I think the court made a decision just from a medical situation to excuse her.
Well, I can take a look at that for whatever it's worth. Okay, so I'm gonna look at the questionnaires on 37. What's the other one I said I would look at?
It was 18.
18?
18 was one that I know we argued about. That was the one with the brother, whether it was either cause for
Precisely. I just need to make clear I get the notes and pull them before I take a look at this in chambers. Dinkins, no motions?
no judge.
I'm on 38.
I apologize.
No, that's fine. I made you stop.
Now, just before you get too far, can I just ask you on 37, to the extent you indicate you're going to look at that questionnaire, it's question 62 and 63, which were of particular concern to us.
Okay,
The state would ask you to look at the totality of it.
I will.
From the vote, we can hold a questionnaire.
Look at page 11. I'll look at, we've all gotten used to going right to the pages. Juror 9 was struck. Was that by consent?
He was a good felon, Your Honor.
Oh, okay.
Cause excusal best action.
Yeah, he was forthright about that. 40, were there any motions on that juror?
There was a defense motion that was denied.
That's correct.
And then 41 was struck for cause. Was that by consent or otherwise?
It was consent.
And 42, no motions, right?
Correct.
43 was ineligible. I don't have a note why.
Got a convicted felon. He was the one who was the habitual violator.
Oh, that's right. 44, I have, there were no motions. Is that true?
Correct.
45, no motions, true? 46, no motions?
Correct.
47, caused by consent, true?
Correct.
48, I had, there was a motion that was granted.
It was a defense motion. We objected. You granted the defense motion.
Okay.
That's correct.
46, I have no motion. I'm sorry, 49.
That's correct.
50, defense motion,
Consent.
oh, it was a consent. 51, consent.
Correct.
Is this where y'all started agreeing mostly? 52, consent.
Yes.
53, a hardship of his wife. In fact, I was, okay. 57, no motion. I'm sorry, 54.
Correct.
54, no motion. 55, no motion. 56, no motion. 57 was caused by consent.
Oh, yes, Judge. That was,
Okay.
that was Coachella.
Oh.
For the record, that's not the defendant's name, but we're keeping that private.
Was nothing that's recorded.
And you all objected and I granted it over objection, or did y'all consent?
I think we agree on that one, Your Honor.
Okay, all right, well, we don't have to go through all that then. Except for a little relief, I guess, comic. 58, that was consent.
The motion to strike the clause under defense.
Oh, okay.
And just back on 57, that was just, I think you probably got it on there, that was not due to anything regarding media or cause like that. It was just for candor to the court.
Well, yes, but if you look, well, all right, I can still look at the totality of the response, though.
Yes, Judge.
Okay, on 58, motion, state's motion to strike.
58.
Yeah, who's, it was a
No,
defense,
It was a consent, Judge. Defense motion statements.
all right, you guys. Lord. 59, was that a consent for cause?
Yes.
Okay. 60, no motions.
Correct.
61, no motions. 62, no motions, right? Well, 63, no motions. 64, consent cause. 65, no motions. 66, consent. Strike for cause. 67, no motions. 68, consent. 69, consent. 70, no motion. 71, no motion. 72, consent. 73, no motion. 74, consent.
73, there was a motion to cause raised by the state that was denied.
Oh, I see that. Hang on a minute. I see that. Okay, 74 consent, 75 consent, 76 consent for cause. So 74, 75, 76, 77 consents for cause. All right. 78, no motions. 79, no motions. 80, consent for cause. 81, no motion. 82, consent for cause. 83, consent for cause. 84, I have medical cause. And I don't believe y'all even explored any aspect verbally. Okay.
You attended the statutory questions.
Yeah. Oh, bless his heart, you know? I mean, my gosh. But for the grace of God. 85, no motions. 86, no motions. 87, no motions.
Made motions. on
We
the
haven't gotten there. Let's back up. 84 was the last one. And then we questioned 85, 86, 87, 88, and 89. And that's where we are. If you go down to 93, he was struck for cause as a student. So he wouldn't be part of any analysis. 194 had a medical excuse. 207 we excused per consent of both parties. Was that language? Does anyone have a note as to why we excused 207? Do you have anything, bro? Yeah?
227 had a vacation, but I don't know if they're,
No, I'm talking about 207. Well, y'all agreed to it. All right. I think that's good enough. Well, I've heard the argument, I've reviewed the motions, I reviewed the law and the motion over the weekend. But now that I've heard argument, I want to take a moment and review everything, review my notes, make a decision. I'm going to break till 1:30, and then I'll have a ruling, I hope. I should. I don't see why not. All right, we're in recess till then. Everyone have a good lunch. Okay, there were two I was going to take. Which ones were those? Make a note.